Welcome to the 52nd session of Great Transition Senior Truth Series. And today we're going to talk about estate planning and elder law. There's a book called Mom and Dad, We Need to Talk by Cameron Huddleston. And they did a bunch of polls and it showed the majority of adults over the age of 50 don't have financial or legal plans in place. Well, today we're going to talk about legal plans. In a few months we're going to talk about financial. The majority of parents, close to 70%, expect one of their children to be the caregiver and take care of finances should they ever need help, either financially or otherwise. Not just doing the finances, but also chipping in money. And they never have communicated to that adult, child, or children that they expect them to do so. Now, isn't that a fun thing to find out? And being a person whose parents are now deceased, and many of us in the room may have had this happen where we didn't know what was going on until something bad happened to mom or dad. So there's another study done by the Wealth Council, and I'll make this quick, but there are 5 basic reasons why families fight in matters of inheritance. And we're going to get into inheritance today and the legal sides of it. First, humans are genetically predisposed to competition and conflict. We know that, especially siblings. Second, our psychological sense of self is intertwined with approval that an inheritance represents, especially when a decedent is a parent. Third, we're genetically hardwired to be on the lookout for exclusion, sometimes find it when it doesn't even exist. You know, she got more than I got, he got more than I got. This seems to be normal. Fourth, families fight because the death of a loved one activates death anxieties of those who are left behind. And we see that all the time. And I think we can relate to that when we've lost a parent. You're kind of desperate trying to figure things out. Finally, in some cases, one or more of the family members decides to distort and escalate natural family rivalries into personal and legal battles. We ever seen that, Linda?
Well, once or twice.
So in most cases, some combination of these five elements will occur into a combustible cocktail of family interaction and rivalry and conflict. Most families, or many families, have been torn apart by this, and I think we've all witnessed it. I've seen it firsthand. Lynn and I are in people's living rooms and kitchens all the time, and there's a battle going on among the siblings. And usually it's because no one really pointed out how they wanted, the parent in this case didn't point out through final documents how they wanted things handled. So the kids are left behind to fight about it. So let's learn how to do this properly, and I'm going to let Linda Solash-Reed introduce herself.
Thank
And
you.
Linda, by the way, is also one of our sponsors.
Thanks, Paul. Well, you heard my name, Linda Solash-Reed. I've been an attorney for many decades. I have been practicing in Florida in this particular area, estate planning and elder law, since 2005. Thank you, Paul, for putting on my material that, yes, I am board certified in elder law by the Florida Bar. See, once you wind a lawyer up, we just don't stop talking, so Paul's going to have to reel me in. On a personal level, when my husband and I moved to Florida, we were the only ones who lived in Florida. In the decades that followed, both his parents and my parents moved to Florida within maybe 15 minutes of us, and since that time, we've been through various different types of illnesses and deaths of 3 out of the 4 parents. So not only do I deal with this in practice, but I have real life experience on the other side as a family member dealing with these issues.
And I'd say that everybody on our team, including our sponsors, has been through these situations personally. Lynn and I, her mother passed away in June, and that was the last of her generation. She was 92, going on 93, and I was convinced she was going to outlive me. But that didn't happen. So we've got a lot of firsthand knowledge personally, but also a huge amount of it professionally. So Linda, from a legal standpoint, what happens when somebody dies?
Okay, first, there are a number of documents, we will talk about some of them later, but some of them are active and help take care of you during your lifetime, like powers of attorney and healthcare surrogates. When someone dies, those are no longer effective. So if you have the power of attorney for someone who has died, don't use it. On another note, assets such as bank accounts, investment accounts, IRAs, they are frozen either specifically by the financial institution or by virtue of the fact that the only person who could control them is no longer available to control them. So it's more or less a freezing of assets at the status quo.
So what happens, you mentioned a couple of words, wills being one of them. You mentioned bank accounts. What happens when there are no legal documents in place? And first of all, what's that called when there's no legal documents in place?
That's called you die intestate or intestacy.
And there's some pretty big name examples of that in recent years. Aretha Franklin, right?
Yes, thank you. Yes, I'm blanking. I'm thinking pop stars.
Yeah, Prince died intestate, Aretha Franklin died intestate.
Thank you.
Howard Hughes, pretty famous one. There was a lot of contesting of the will, but so what happens when there are no legal documents?
When there are no legal documents to say who gets what, there are at least two areas of concern. First is who takes control, who manages the process, and then what might be the big money question, pun intended, is who gets everything. Who gets everything is determined by state law. So I can give you a rough idea about who will get your stuff in Florida, but not so much for Prince or Aretha Franklin because it's state law governed. Sometimes it works out that the statute will give your assets to the people you want them to go to, sometimes not. But where dying intestate is the real problem is, let's say I have 3 children and I want everything to go to 3 of them equally. You know, so far so good, the statute would do that. But what if one child has issues, has a problem? Either was born with a developmental disability, developed a mental health, a chronic issue and can't manage themselves, or has an addiction issue or another type of issue that will prevent them from managing assets. Well, I can plan for that situation, but if the statute gives it to them, that child who has the problem and can't manage money or might be kicked off of certain important government benefits by inheriting that money will just get it. The statute, it's not nuanced.
So it's not as easy as there's 3 children who are heirs, there's no documents, we just divide it and everything's fine, because it may not be fine.
Correct. It may not be
The
fine.
cases are very particular.
And you know, statistics on divorce and remarriage, and the older we get, the more blended families we have. Not necessarily divorce in our cases, but because some of us are going to outlive our spouses and might be blessed to find another spouse. When you get into step families, even if everybody gets along perfectly well while everybody's alive, I point out to what Paul mentioned, those issues. You can double, triple, or quadruple those issues when you're dealing with step families. So it's extremely important to take care of your plans if you have a step family or any issues of any variety in your family. And issues can be good or bad. Too, suppose that there is, you know, a grandchild you want to take care of. Well, the statute doesn't care if you have a grandchild you want to take care of.
So it's not as simple as it'll just go to the kids. So moving on, if we're going to do something, I guess probably one of the first things is to figure out who would best administer personal, not from a legal standpoint, but who best would handle things, who would best be the personal representative. And what is a personal representative?
Okay, a personal representative is also called an executor, same thing. Florida just uses personal representative. They are the person who is charged with carrying out your wishes as you express in your will. For most of us, the personal representative is also a beneficiary, as in you might name a child to be your personal representative, but not necessarily. Totally different roles. So I might decide Paul is such an even-handed individual who's worked with so many crazy families, maybe he'd be great as my personal representative. He would still be a suitable person, even though he is not a beneficiary. When I talk to families about who should be personal representative, what I say is, do not say my eldest son or my eldest child or whatever designation you think is suitable. I'd say think of it as a job. You're filling a job. And what a personal representative needs, above all else, is an ability to focus on details. Now, I am assuming that whoever you're considering or you're thinking about is going to be honest. That's kind of a given, that whoever you're dealing with is honest and trustworthy. But there can be people who are not good with details, who are, and I don't mean this to disparage my artistic friends, but for people who might be more in the artistic bent, who see big pictures and aren't able to focus on the checklists and nitty-gritty, they might be absolutely trustworthy, but not who I would pick to be my personal representative. So if your eldest son is a wonderful artist, don't make him your personal representative.
And don't necessarily make it the favorite child either.
No, and one thing we get into, maybe not in estate planning 101, but 02 or 03, and this is things that we would talk about if you're in my office discussing this, is whether or not in your situation a family member is best. Because let's say, going back to my 3 children, let's say 2 of my children, wonderful, stable, have their lives together. The third doesn't have a diagnosis, but let's say doesn't have her life together and tends to be contentious about everything. Well, one of the other 2 children may be well qualified and able to serve as personal representative, but do we want to put them in a position where they have to deal with a troublesome sibling? Would it not be better, perhaps, to name an independent third party as personal representative in the hopes of the siblings maintaining a relatively good relationship with each other?
So let me ask you, and I'm going to come back, we're going to kind of bounce around a bit here, but what are in general, the duties of the personal representative, and how much discretion do they have relative to that?
Okay, not much discretion. I'll answer that first because that's easy, but this is a pretty straightforward answer as to what their duties are. Their duties are to gather all the assets of the deceased, to gather and pay all just debts, if there are any, and then distribute what is left in accordance with the terms of the will. So while I can't say there is no discretion, there's always a choice about little things, but as far as the major things of who gets what, no, there's no discretion. And when you have a will-based plan, it is administered according to certain rules in the probate code, and it very much lends itself to a checklist. So we don't divert. Even in my office, when we probate a will, we have a checklist. It helps us, and it could help show that you do this, and then you do this, and then you do this. There is no discretion. That's why I say that a personal representative, the ideal person, would be one who works well with checklists and doing things in proper order. And I'm sorry to keep banging the table and making...
So we've been involved in several of these through Linda's office, on the sidelines, so to speak, but involved. And she's very literal when she talks about having a checklist. There are certain steps that have to happen, and the personal representative is in charge of doing those steps. You're telling them what to do when.
Right.
But if it says 33, 33, 33, it doesn't mean, well, he had a rough life, and I feel like I should give that sibling more money.
Exactly what we cannot do, yes.
And so it sounds like a lot of work. If they're not using a family member, they're paying for it, correct? The estate pays for it.
Correct.
Well, what about family members? They're going to do it for free? Is that the idea?
No, family members can get paid. The statute says, in the way only lawyers can write statutes, is that 3% of the inventory value of the estate is not unreasonable. So in English, that means a personal representative can take 33% of the value of the estate.
And that's off the top.
Correct, that's off the top, as is, because lawyers write the statutes, our fees are off the top as well. And other things certainly are off the top. Sometimes you pay an accountant, sometimes you have to sell real estate and there are costs involved in liquidation of assets, whether it's real estate or others. So it's net of all the fees for professionals and net of all the just creditors that need to be paid.
And I think any of us in the room who've had to work on, I don't want to say had, who were tasked with settling an estate for a parent, grandparent, you know there's a lot of work involved. I've done two, for both, one for each of my parents, and it was tremendous amount of work. It took both cases over a year to settle it. And compensation, in my opinion, should be, and it should be pointed out in your documents that you expect the personal representative, this is Paul's opinion,
Okay.
that you expect the personal representative to be paid. So let's talk about documents. First, you mentioned power of attorney, and power of attorney is a wonderful document, but does it have an expiration date is part of what I want you to cover, but tell me about the power of attorney.
Okay, durable power of attorney is, in general, the single most important document that every adult needs to have. And when I say adult, and I'm looking at you, Isabel, I mean everybody 18 and up. Because once you hit your 18th birthday, neither your parent nor anybody else can go to the bank and do transactions for you, can speak up for you in any manner. One of the biggest myths I hear, and it's so frustrating to me, is, oh, I'm 75 and healthy, I don't need a durable power of attorney. And I say, but wait, when my daughter turned 18, I had her fill out a durable power of attorney and some other documents at a colleague's office and sign them, because this is one where it's so important for me to walk the walk. You need a durable power of attorney. Think about if, God forbid, you're hospitalized, you have a stroke, you're hit by a car on I-4, and besides having your family call Morgan & Morgan to sue the person who hit you with their car on I-4, your family's going to have to make sure your bills are paid, they're going to have to file insurance claims, make sure everything is in order. Well, how do they do it? The answer is that if you don't have a durable power of attorney that names somebody to do these tasks for you, they don't do it, or they can't. Or they come to me really quite desperate to say, what can we do? And I can say, I can help you, but we're talking about a couple of month process to have a guardian appointed, and it's not the ideal. To say it's not ideal, that's truly an understatement. It's not the way you want your affairs managed. It's not effective, it's not efficient at all. And it can just, when your family is dealing with the emotions of somebody who became ill or had an accident, the last thing they want to be dealing with is all these legal issues. I mean, I know I'm charming and fun, but you don't want to see me when mom or dad are in the hospital or your spouse is in the hospital.
And they may not be competent at that point.
Right, yeah, it might be too late. You can't stop. Hang on a sec. Exactly. You need a certain level of capacity to sign a document, and I can't address, because that's one of those things that you kind of know it when you see it, and how we determine capacity to sign documents really is a whole other topic. But think about somebody who's in a coma, or think about someone who is on a morphine drip for pain. Those are two situations when you cannot sign a power of attorney. And that's the time when you need it most.
I personally ran into a situation, my father was 72 years old, roughly, head injury, and he had no power of attorney. Now, I had the good sense to know that there needed to be a power of attorney, so I got the documents put together by his attorney, went to the hospital to see him while he was still cognizant and conscious, and signed that power of attorney, and then he was in a coma for 45 days. When he came out of it, he had no idea who he was, where he was, or who I was. And that took another 60 days, so effectively for 3 months he was completely out of it, with incredible medical bills not covered by insurance. Many of them were, but many of them weren't. And had we not had that, it'd have been a real nightmare, because Paul didn't have that money in his checking account.
And that's the thing about timing when you ask, well, is it too late? Well, I don't know. Today you all seem in pretty good shape. You can all sign powers of attorney. But that's the only thing we know for sure, is it's not too late right this second.
So,
We did have a question. Do you want to, did you have a?
Can you assign more than one person on the power of attorney?
okay, so what we're going to do on the questions is repeat them so that they get on the tape. And the question is, can you have more than one person's power of attorney?
Yes, and not only can you, but I urge and encourage you to name a primary and then a backup. There can be two at once, but if that's something you wanted, that would be a more personal discussion, because there's some pluses and minuses to having two at once.
And while we're on powers of attorney, they just pulled off the internet, right?
Well, you can.
I'm saying this very much on purpose.
Well, you can, but what that leads to is the aforementioned panicked call to my office when the person was in the hospital and saying, I had a power of attorney, but I couldn't do blank, blank, blank with it. What do I do now? And that's when I say, well, sorry, now you're looking at the guardianship scenario.
Yeah, this is not an internet document scenario. And we can give you case after case of that. One of them is one she just cited. Person, I said, well, we need to get you in to see an attorney if you don't have one, Linda. Oh, no, I'll pull it off the internet. And the next phone call was, well, what's her phone number? I'm at the hospital and they're telling me this is worthless. And then she went to the bank and it was worthless at the bank too. So I know that those documents have changed quite a bit. How often should people update a power of attorney?
Okay, well, this seems like ancient history, but I still see powers of attorney come into the office from before 2011. So, first point, if you have a power of attorney done before 2011, redo it. That was the date of a major statutory rewrite. And it pretty much means that your document is worthless. The other key to redo it is, has something changed in your life? As with all of the legal documents we're discussing, the triggers for a review are the same. Are the people you named to be your helpers, are they still the right people? Has their situation changed? Have they moved away? Have they had health issues? All that aside, the rule of thumb is every 3 to 5 years, it's a good idea to review all of your legal documents. Doesn't necessarily mean you need to change them, and quite often we look at documents. If people come and say, hey, we want to check up, I look at documents, we confirm that what they did a few years ago is still accurate and what they want, and we say fine. But sometimes it's like, oh, I forgot I named that person. Or, oh, I don't want them to get anything anymore. So if there's a major life event, or 3 to 5 years.
So, does a power of attorney have an expiration date?
When somebody takes their last breath, that's when it expires.
So it is no good after someone dies?
Correct.
Because we hear this all the time. Oh, I have a power of attorney over mom, dad, grandma. So I've got everything handled. We don't need anything else. And when we explain to them, well, no, when they die, it expires, that there's always an oops.
Yes, it is.
And a deep inhale.
And it's where I hold my breath and say, You didn't go and change assets or move things around since they died, did you? And I sit there like, hoping to.
So the document's most important when we're alive is power of attorney.
Power of attorney.
The other documents we're going to talk about are worthless unless we do something while we're alive, because otherwise you don't have the documents. So let's talk about a will, simple will.
Okay. A simple will is a document that says, I, Linda, appoint Paul Henderson as my personal representative, and I give my estate in equal shares to my 3 children. Okay, I don't have 3 children, and in reality, my husband would be number 1, but that's what it says. That presumes that my 3 children are all over the age of 18. Because if you give something directly to someone who is not a legal adult, there's a whole lot of complications that are easily avoidable. And all these 3 children have capacity, and that they're old enough that they are able to manage the sum that they will inherit from me. Because sometimes you have adult children who might be 30 plus or minus, well settled, but perhaps you're fortunate enough to have an 8 or 9 figure estate, and you don't want them to have a multi-million-dollar inheritance at one time for them to blow. So.
And things like there might be a grandchild involved, and if you're not reviewing your documents on a regular basis, the next thing you know, I'm regressing here for a minute,
Sure.
that grandchild's 18 years old. And then you've got a different set of circumstances.
Or I have to, my stream of consciousness says that the other thing to think about when you have your 3 adult, very competent children is if you have a concern about a current or to-be spouse and potential ex-spouse being in the picture, then there are ways to plan for that and accommodate those concerns as well.
So we move on, explain the will. Was there another question? Yes, ma'am.
Can you designate joint personal representatives?
Say that again?
Can you designate joint personal representatives?
It's a question again, could there be more than one person as a representative?
Yes, you can designate 2 people as a personal representative. I would say that the one rule for personal representatives to bear in mind is that family members, even extended family members, can serve no matter where they live. If you want somebody to serve who is not related to you in any way, they must be a Florida resident. Okay.
I handled my parents' estates. They lived in the Midwest from here, did everything from here. But very good point. We were related, so we were able to do that. So let's move on. We talked about a will. Now, what about trust? We hear about trust all the time. Everybody has to have a trust.
And as Paul knows, any phrase that starts out with "everybody must" does not fly with me, because just like ladies, who of us can wear one-size-fits-all clothing? Yeah, well, legal documents are the same way. First disclaimer is that lawyers, in our effort to confuse the general public, use trust to mean many different types of documents. The type of trust Paul is asking me about is called a revocable living trust. What a revocable living trust does is it can do the same things that a will does, which says who gets what after you're gone and who manages that process. The difference is instead of a personal representative being the manager, it's a trustee. In addition, while a will only does anything or is active when you are dead, a trust does things and has a purpose and can be used while you're alive. A trust is like an empty bucket. And what we do if you decide that you want a trust as your main estate planning tool is we look at the assets you own and say this, and this asset need to be managed in the trust. So we take it and we put it in the bucket. that is the trust, by changing the title to those assets. And then whoever is the trustee of your trust, and let's say when I set up my trust, I'm my own trustee, but I put Paul down as my successor in case I become incapacitated or at the time when I die. I'm managing these assets in this trust bucket. If I'm unable to manage them, Paul takes over and manages them. And then at the time of my death, Paul would look to the wording of my trust and say, you get this, you get that, this bill is legitimate, it gets paid. The difference between a will and trust, besides that one is only active and does anything when you're dead and the other has some lifetime utility, is how they're put into place. Is a will is activated or put into place by going to court and opening a probate process. No, probate is not the devil's process. It is simply a process with a set of rules that we follow. And it has the advantage of having the court overseeing that your will and the wishes therein are carried out properly, but you do have to follow the rules and go down the court's checklist. A trust is not managed within the court system. Paul, as my successor trustee, I mean, he's not off the hook from contacting a lawyer, but Paul would contact a lawyer and get some documents prepared that show that he is now the trustee of the Linda Trust. And then, without going to court, he could take this document and go to my bank and say, I'm the trustee, this is what we need to do. So, which one is right for you? That is something we discuss, you might discuss with me or any estate planning attorney you see, and it's not based on trusts are good or wills are good. It's based on your personal situation. It's based on what type of assets you have. And most of all is we can probably put your plans in place using a will or a trust. It really comes down to your wishes. So that's full circle. One size doesn't fit all, but you do get to choose and you do have options.
And the they said crowd is really dangerous because people tend to act, we as humans tend to act on what they said, what I heard and they said. And so you could take two people with same number of children, same number of assets, and one would be perfect for a trust, and the other one, and possibly need the trust, and the other one would be perfect for a will. But in any case, there needs to be a final document of some sort, right?
Exactly right. Yes, a will or a trust. And
So let's talk about real estate. Interestingly, in the state of Florida, 82% of the people over the age of 65 own a home. In the general population, it's more like 60%. And Lindy, do you have a question?
Oh, I just wanted to know, Linda, whether your statement about being a Florida resident applies to both what I call the executor and the trustee.
So the statement, or the question is, we talked about being a Florida resident or an out-of-state resident to the decedent, and do you have to be do both parties, if there's more than one personal rep or trustee, do they both have to be in the same state?
No, my question is...
I think I have it, Lindy.
So you repeat it.
Okay, I think the question is, does the rule about being in state if you're a personal representative and not a relative also apply to being a trustee? Does that?
Yes.
Oh,
Okay, so the answer is no. Trustees can be located pretty much anywhere. That rule about the executor or personal representative being either a relative or in state is only for wills.
and is that strictly to Florida, or is that a national thing?
Oh, there are 50 states and 50 statutes and rules.
Okay, so I go back to, and the reason I asked that, I go back to they said, my buddy in Oklahoma said, my friend in Indiana said, my childhood, and so on. So just because they said it, and if they lived in another state, it probably isn't true in Florida. I would bet on that. Cheryl?
I'm trying to understand between trust and a will. If you put your home in the trust, can't you that way bypass a lot of probate costs and fees?
And we're moving into that one.
Depending on what you put in your trust?
This has to, the question is about somebody's personal residence, which in the state of Florida we call the homesteaded property, and that being in a trust. So we're going to talk about deeds. Do you want to talk about deeds as part of that, or you want to go ahead and answer that question? Go ahead and answer.
I'll answer that question in general terms, is that for any asset, whether it's your homestead, other real estate, or an investment account, if it's titled in a trust, it will not go through the probate process. The probate process is how wills are put into effect. So if it's titled, if anything is in a trust, it is not going to pass through your will.
The reason I ask, I think that I read somewhere that in the state of Florida, going through probate is like 6% fees of your assets. And that's why I'm thinking, oh, well, I would bypass those fees if I used a trust.
Well, that's a,
Yeah.
and I don't know if we want to get off on that or not, but she's now asking about what are the fees to go through probate.
Probate. So the short answer is there are fees, but it's not 6%. So let's maybe circle back to that.
Okay, that's probably a pretty specific question to be sitting in front of somebody. So let's get into deeds, because, and deeds dealing with personal, with real estate. And so there's several different types of deeds, and the standard deed on most people's home would be a warranty deed.
Warranty deed, correct.
And it says, we own it, no one else does. There's title insurance with that. The purpose of the title insurance is to ensure that the deed belongs to the person on the deed. And if there's ever a dispute about that, the insurance kicks in to pay for research and so on. So that's the normal everyday deed that most of us have. The second one is a ladybird deed.
Okay, just curiosity. How many people have heard of ladybird deeds? Okay,
So
that's...
we've all heard of it, but do we know what it is?
Okay, well, if you're following along, I'm going to skip ahead or blend the questions together, because...
Well, we're talking about the life estate, ladybird, enhanced life
Enhanced life
estate,
estate,
and
right.
so you're going to go over
Those are all three, we're going to clump them into this part. Because a ladybird deed is the name for what lawyers refer to as an enhanced life estate deed. So I will tell you briefly what a non-enhanced, or what a regular life estate deed, and then add on the enhanced part. A life estate deed says, I, Linda, own my house, and I give it to myself to live in it for my lifetime, but when I die, I'm not going to give it to Paul. I give it to Isabel Henderson. We record that deed. When I die, the house is Isabel's. The good side to that is that all Isabel has to do is take my death certificate down to the property records and the house is hers. The downside of it from my perspective is that I changed my mind and I need to sell my house so I can go live at Westminster Winter Park or the Mayflower, and I need those funds to buy in. But now I can't do it because Isabel has to sign off. And while she's a wonderful person now, something happens and 10 years down the road she says, heck no, Linda, I'm not going to sign off, so I'm stuck. What an enhanced life estate deed says starts off the same, I, Linda, own the house, I give it to Linda to live in for her lifetime, with full right to sell, lease, mortgage, do anything I want with it, and if I do none of those things, and I die owning the property, then it goes to Isabel. So the good news is Isabel will still only have to take my death certificate down to the property records, record it, and the house is hers. But if I do need to sell it for whatever reason, or if I want to take out a line of credit to pay for some repairs or whatever, I can do that with no fuss, no problem, because it's mine. Although I should probably get our title friend, Mark Wright, to talk about this. I have recently had to transfer assets out of a Lady Bird deed and back in because somebody refinanced, but that's a whole other story. But in theory, Lady Bird and enhanced life estate deeds work well in certain specific circumstances. Again, not one size fits all.
And I think we're kind of pointing out a lot of the challenges here of legal documents, because there are legal documents involved that are exceptionally important, and if not done correctly, can create a real mess.
Right.
And Linda?
Is it still considered a homestead or not?
Is the property, the question is, when a Lady Bird deed enhanced life estate is put in place for the benefit of somebody else, the owner can stay there, can it still be homesteaded?
Okay, that is a great question, because that leads into a couple of quick points I need to make about it. Yes, it's still your homestead. However, I am handing out a sheet to all clients who sign Lady Bird deeds that advises them to do two things. One, to don't just assume that the property records folks have your house still listed as your homestead, because even though doing a Lady Bird deed doesn't take away your homestead, sometimes the records may not be properly changed to reflect it. So you have to take it upon yourself to make sure that you don't lose your homestead exemption. And I don't necessarily think this is correct, but you also, when you do a Lady Bird deed, you have to call up your homeowner's insurance. And in my case, I would have to say, hey, I need to add Isabel Henderson as an additional insured, because there was one horrible case where there was a fire in the interim period when after somebody died and the Lady Bird deed was in place, and the beneficiary, the Isabel person, was not named on the insurance policy, so the insurance company didn't pay. And I think that is the wrong outcome, but I don't want my clients to be test cases. I want you to be sure and add your remainder beneficiaries on your policy just in case.
And you know, Linda makes that comment, and certainly that's an exception, but Linda and I have closed over 500 properties in our career, and we've seen a little bit of everything. So these things do happen. We've seen houses burn during the period of time, even after it's under contract, just an electrical fire, whatever happens. So we've had some questions from people, and you've got it on yours too. And I want to move on to these, because these are exceptional kind of things, or exception questions. But if somebody has a disabled child, maybe it's their child, maybe it's a grandchild, and they want to try to take care of them after their death, what kinds of things are available, even if they don't have substantial amounts of money?
Okay, there are absolutely good ways to set aside funds for someone who has a disability. And there are two reasons for making special accommodations. One is that oftentimes people who have disabilities, if they're intellectual or even some physical disabilities, are not able to manage money on their own, even though technically at age 18 they are legal adults. So you want the money set aside in such a way that it's managed properly for their benefit. The other piece of it is you want to be sure that if they are getting government benefits based on financial need, primarily Medicaid or some form of government benefits, that the inheritance doesn't kick them off their benefits. So the type of trust is called a special needs trust, sometimes called a supplemental needs trust, same thing. And it is one of those areas where you really do need an expert. Because as always, there's a couple of kinds of special needs trusts. One kind is where if I am a disabled person and I get some money, there's certain circumstances, I can put it in my own special needs trust. The catch is that at my death, the money goes to pay back whatever Medicaid paid for my care. For better or worse, that's the way it is. But if I have funds and I want to set aside money for a grandchild with special needs, because it's my money, and I don't have to give it to the grandchild, but I choose to, if there's anything left after my grandchild's life, I can say, oh, it gets distributed to my other grandchildren. So it's very important to draft the right type of special needs trust for the right person.
And we've seen many different kinds in recent years. There was a family we were working with, and the mother was taking care of adult son. I mean, he was reasonably competent. He held a job, but he could get taken advantage of very easily. He had no idea what money was. He had some learning disabilities, and frankly, it was killing the mother. She was quite elderly. She was in her late 70s, and she was becoming in very poor health. And what they wanted to do is sell the house, take the money, go rent something, and then that would be able to bring in care for the son. Ended up with Special Needs Trust. He's in a group home, thriving, doing extremely well. She was able to take the money out of the house and move to a continuing care community where she thrived for many years. Otherwise, she probably would have lasted another year or so. And so there's many, many gyrations of that. We've seen also where there's a family with an adult child that has learning disabilities, mentally retarded, whatever term you might use, and they're just kind of off the grid because the parents just never really took them anywhere. It was that generation. We handled the family from up north. And so the Special Needs Trust was able to take care of that person's needs for the rest of their life. So if somebody wants to age in place, what are probably the most important documents they have in place? Because many people think that, well, I'll just stay in my house forever.
Well, certainly, the same documents we've spoken about. Or maybe we didn't mention healthcare surrogates, but yes, durable power of attorney, healthcare surrogates, special end-of-life wishes, whether you might call it an advance directive, a living will. Some of you might have seen the 5 wishes, which 5 wishes, here's my pitch. I love it as far as being an expression of your wishes. I'm not crazy about it as a legal document, although it can serve in some states. Those documents are important, and of course, who gets what, whether it be through a will or a trust or one of those methods. So that doesn't change a lot if you want to age in place, but what we layer on is making sure that perhaps you look at how you pay for help in the home, how you get the home ready. And this is really not exactly legal issues, but they're part of what in the elder law community we deal with. Like, I'm not going to tell you how to install grab bars in your bathroom, but I'm going to say, have you had your house checked out to look at those type of issues? Have you spoken to someone, maybe like Paul and Lynn, who might talk to you about aging in place, but might go over what other options there are that you may not even know exist in the community for you?
And coincidentally, our next subject is how to stay at home forever, next month. I'll come back to that. I want to talk about making wishes known. And I think it goes without saying, I have arthritis. I go to the doctor, rheumatologist for my arthritis. I had a skin lesion that turned out to be cancer. I didn't go to the rheumatologist. I went to the dermatologist. We seem to be really good about that with medicine. We don't go to the brother, sister's, uncle down the street who's a good friend of dad. But that seems to be the way we choose attorneys. So why go to an elder law attorney to do this stuff?
Okay, because I'll tell you how I got to be board certified in elder law by the Florida Bar. I studied for a test, and when I say I studied for a test, with 4 other people, we met 6 months weekly it wasn't Zoom at that point, it was a conference call, and we studied and we went over all the areas of law related to elder law. We took a test, much like the bar exam, and we had to get references from the community, from fellow attorneys who practice in the area. We had to complete many, many hours of continuing education above and beyond what's required just to keep my bar license intact. And I have those continuing education requirements that continue on, and I'm in my 3rd cycle, and when I had to renew my elder law certification, I again had to get peer reviews. So I can't tell you that there are attorneys who are not board certified who are well qualified. But for those of us who are board certified, you know what we've been through and you know the type of review we had to pass. I'm not, I was telling somebody else, is that elder law is kind of the cool area of law because it is a very important, it is a growing practice. So a lot of people out there will say, oh yeah, I do elder law. Well, those are the people who do something as simple as durable powers of attorney, and they forget to put in the clauses that we need if I'm going to help you qualify for Medicaid, because there's specific language and specific clauses. So that goes back to why, number one, don't get a power of attorney off of an internet, but also why you might want to be sure that if you're looking for an elder law attorney that they've at least been practicing in the area for a while and they have a little bit of experience doing exactly what you need to do. I mean, heaven knows, every week, if not every day, I come across a new and unique situation. But in general, I've seen a lot of the patterns that come up in all of our lives. We're unique, but there's still patterns, there's still similarities. I can give you guidance based on what I've done and the families I've helped.
So Lynn's going to come up, and you have your mic on, and you might take off your mask. We're going to talk about, so we've talked about these documents, wills, trust, estate, the deeds, Lady Bird deed, enhanced life estate deed. But how do we let our kids know about this? How do we let the people who will be affected know about it? So how do we put our personal wishes in writing? And Lynn's going to talk about that.
So I just want to make sure everyone was aware that there is a program out there called the Conversation Project. And you can look it up online. It's conversationproject.org. And it will give you a guideline on how to speak with your family members to let them know what your wishes are. It does go into what you're looking for at the end of your life and those end-of-life decisions that may need to be made. But it also leads into conversations just about, in general, how you want to live your life at this stage in your life. Do you want to stay at home forever? Do you want to, when it's needed, have a family member maybe help bring care in? So it gives you an opportunity to sit down with your family members, maybe not just once, but several times, to talk about what you want to have as you age. Linda mentioned the 5 wishes. I've got a copy of it here, and there's a stack of them on our back table with all of our other sponsor materials. And I encourage you to pick one up, just take a look at it, see if it's something that might be of value to you. And it is, I agree, Linda, it maybe isn't necessarily the best legal document, but it does give you things to talk about with your family so that your wishes can be carried out. The other thing I wanted to bring up...
And while you're talking about that, you want to talk about our personal experience? We actually did this with our children. It was
Right.
very interesting.
Yeah, we did with our children several years ago, and not only went through what we wanted for our end of life and all of that, but let them know about plans we had for how we wanted to live, the idea that we were going to be downsizing, and just kind of talk to them about a lot of family things. And I think that the more your children know about what you want, then the better prepared they are. And I will say that in my own family, my parents were very prepared, very much planners, and that was a huge help to me and a real gift to me when I needed to be able to manage their affairs toward the end of their lives and then after their death. The more that you can prepare your families for that, the better.
We hear this all the time. People will meet with them and they're decide, well, we're going to downsize to whatever downsize is. And then they call us back, oh, well, we talked to our son, daughter, and they said, if you do that, I'll never talk to you again. That was my house. I grew up there. And so by having these conversations, you'd be surprised. It happens a lot. And my response always is, I didn't see your name on the mortgage. But by having that conversation up front, and we said to our children, folks, we're not staying here much longer. House is too much for us. It's just not what we want to do. We want to do other things. We explained it to them. And their comment was, well, that makes sense.
Mm-hmm.
So we weren't springing anything on them.
So there weren't any surprises. So,
Okay, grab and go binder.
grab and go binder. I think this is an awesome way to keep your important papers and items together so that even if you needed to find things quickly or a family member did, it's all in one place. And we got this idea from an organizer, a professional organizer that we have used and been in contact with. She's actually been a speaker at some of our panelists, as a panelist here. And the idea is that you buy a binder from Office Depot or Walmart or wherever you go, and then there are sleeves in here, and they're open at the top, and you can use this to put in your important documents. And some of the documents that they kind of recommend you put in here would include things like the legal documents that Linda is referring to today, as well as maybe a list of where your bank accounts are. If you have a financial planner that is helping you with your finances, their information, insurance policies, copies of your driver's license, if you have deeds to your house, titles to the car, all of those kind of important documents are really best kept in one place so that you know where it is when you need it. A list of your credit cards. Another item that is really important in this day and time is passwords to all the millions of different websites and different passwords that you have for doing, if you do mobile banking or all those kinds of things. So there's a lot of great information that can be kept here. It's just a matter of kind of pulling it all together in one place.
So we're going to move on to questions, but I want a couple questions that we got of people who weren't able to come today, but they sent questions. I have an adult child who's unable to live on their own. How to provide for them after my death with special needs trust. We covered that.
Yes.
Who needs a power of attorney when ages and stages? Everybody over the age of 18. 18 and over.
18 and over, got it.
And I heard a very compassionate talk about that one time from a lady who coincidentally was an attorney, talking about her 19-year-old who was laying unconscious in the emergency room, and the doctor said, she's stable. Well, what's wrong with her? Can't tell you. HIPAA laws. What are you going to do? Can't tell you. HIPAA laws. Now, when she came to, they executed a power immediately, and then the mother was able to help guide that medical care under the wishes of the daughter.
We had a question.
Yes, when I talk to our clients, I tell them, the caregiver especially, to get the durable power of attorney instead of the power of attorney, because the durable power of attorney is still in effect when they lose capacity, when they are not able to make decisions anymore, they have dementia or some type of dementia or Alzheimer's disease, so they can proceed, because if they do have the power of attorney, it ends when they don't have capacity, correct?
So
Correct.
the question, you're going to define a little bit more power of attorney, durable, non-durable.
Correct. Correct. The question was, more of the statement that you need a durable power of attorney, because the durable in the title means that it is effective starting when you sign it, and it continues to be effective whether or not you become incapacitated at a later date, ending when you die. Correct. And my bad, because I use the word power of attorney interchangeably with durable power of attorney, but in my head, which thankfully you can't see into, I mean durable power of attorney. These days, most powers of attorney you come across are durable. Occasionally, still, we might have a special power of attorney. Oh, I need Paul to do a real estate closing for me, so I'll give him a limited power of attorney for real estate, but absolutely, must be durable.
Yeah, we deal with powers of attorney all the time, but the durable is the new one. Where do I start and what things are most important? I think you need to start with deciding that you need to do something. And I would dare say that everyone in the room needs to review their documents and do it with a person, an attorney who specializes in elder law. And that's not meant to be an advertisement for Linda. Linda's a superb job, and we use her all the time. There are other attorneys in town that are very good, and we have a list of them. We don't have it with us today, but and certainly we defer to Linda for our clients. Anything else, Linda?
No, that's right. The time to start is now. It gets back to that joke, is when is it's too late? And it's too late as long as you can do it. I mean, it's not too late.
So, questions? Yes, ma'am.
My husband and I each did a holistic will when we lived in Texas. And I was told Florida does not allow holistic wills. First question is, why is that? And the second question is, we've been told that in Florida, because they were done in another state where it was legal, that worse came to worse. In other words, we didn't have a superseding will done here in Florida, that the holistic wills in Texas would be under. So is that true?
Okay, so the question is, are holistic wills in Florida? And this is a superb question. I'm glad you brought it up, because most of us aren't from Florida. And so we run it all the time. People have been in Florida for 4 or 5 years, 15, 20 years. They had a will in place in Indiana, and now they're in Florida. So out-of-state wills moving to Florida is the second part of that.
In general, the second part is that it depends. Some out-of-state wills meet the formalities that Florida requires and would be able to be probated without any issue. Some not. So if you have a will from another state, it is advisable to at least have it reviewed to make sure it still accomplishes your goals. Now, I'm not clear of the term. I know what a holographic will is.
Holistic is handwritten.
Right, it's the same thing as a holographic. And the reason why, I mean, I'm sorry to be flippant, because the statute specifically says holographic or handwritten wills are not valid. Yeah, that's the
They are in
legislation.
Texas.
The thing is, anybody that's moved here has probably been here for a little while. And so whatever you wrote a little while ago probably isn't relevant, or not as relevant as it was when it was written. So it's time to do something no matter what.
Right,
Ours is though, because we made it very straightforward, not all kinds of detail, no codicils. It just says that we leave everything to be split equally between our children.
And
that's still true today.
And I'd say that to anybody in the room, that I would still say that it's time to have it reviewed by an attorney to make sure that nothing's changed. And I've seen this happen many times, and where they'll say, oh, it's fine, and then the parent dies, and then 4 zeros with a number in front of the 4 zeros later, they're getting the documents corrected, if you will, or serviceable, so they can settle the estate. So they're spending tens of thousands of dollars where they could have spent a few $100s on having documents reviewed.
Yeah, just one real simple way that wills that are valid in other states can still cause problems in Florida is we have what's called a self-proving affidavit, which means after you sign your will in front of two witnesses, you and the two witnesses sign again in front of a notary. I mean, it's at the same time, it's a different page. That's called a self-proving affidavit, and what that does is the witnesses are there swearing that you signed in front of them. Well, a will is valid without the self-proving affidavit, but what I would have to do to put that will into effect is to find the witnesses, have them go to a clerk of court locally and swear out that they really were there and you were really there and that you signed. So even if your Texas will were valid and enforceable in Florida, is it really cost effective to have a Florida attorney try and track down whoever your witnesses were and get them to go to a local courthouse and swear in front of a deputy clerk that they really did see you sign? I mean, it's just so much more cost effective, especially if you have a simple will. You're not, investing in anyhow, that's,
Okay.
I'm
So
showing.
what other questions? Yes.
Titling of accounts, bank accounts, financial accounts, you can put various titles on, but you can also use beneficiaries to keep them out of probate, correct?
That's correct, and in some
The
situations.
question, I'm sorry.
I'm
The
sorry.
question has to do with bank accounts and titling of bank accounts, and that is a really good question because people can get in a pickle needing to spend money that they don't have.
Okay, putting titles on bank accounts. That is definitely something we discuss in an estate planning consultation, and in certain circumstances, it works great. When it doesn't work great is if the beneficiary that you want to name is subject to a divorce, has creditors, becomes incapacitated themselves, or predeceases you. Or if, please don't do this, if you put somebody as a beneficiary who is a minor. Don't ever put a grandchild. So yes, beneficiary designations are part of the overall plan, and it works at times for people who have very, very super simple, straightforward situations.
Okay, other questions? Yes, sir.
If you're married, and at what point is your spouse playing in this whole thing? Are they automatically considered to have the access to your documents and your accounts and your house and all that?
So in a marriage, what are the spousal rights? And I think another piece of that is the spouse automatically a power of attorney?
Okay, that's a great question, and this came up with dealing with a client's family this week who he recently passed away. No, for power of attorney during your lifetime, no, a spouse has no rights under the durable power of attorney. So even if you are married, you need a durable power of attorney. The exception is, of course, if you and your spouse have a joint bank account, you have rights under that bank account, not because you're the spouse, but because you're a joint owner. So that's the difference. Now, spouses don't inherit things automatically either. Certainly, it appears that way for oftentimes long-term married couples who are in a first marriage long-term. They own everything joint. So when the first spouse dies, there really isn't much to do to have everything titled in the surviving spouse's name because they already own those accounts. So, and that was exactly the question I had come up from this client's family, is that, oh, so we didn't need a will anyhow. And I said, no, you didn't need a will when Pops died because he owned everything jointly with Mom. You needed each of them needed a will because you don't know which one was going to pass first, and whoever was the survivor would need their will. So does that answer all what you're asking?
So we're going to move on. Lindy, I'm going to let you stick around and talk to Linda afterwards because we're coming tight on time, and Linda has an appointment. She can stick around for a while. Next month, we're going to talk about staying at home forever. I think that may be the goal of many of us, to try to stay at home forever, and we'll talk about how to do that. Please visit our sponsor table and back. Several of the sponsors are here, we introduced earlier, and we'll stick around to talk to you. And so what did we learn today that we're going to take forward? I trust you'll tell other people about the seminar. Did we try to sell you anything? Good, because we're not here to sell you anything. We're here to provide information and education. I'd like to end with a quote. No one actually dies until the ripples they cause in the world die away. And it's by an author, Terry Pratchett. And I think we want to make sure those are smooth ripples, not a tidal wave. And if by doing your legal documents properly and the things that we talked about with the Conversation Project and letting your family members know what your wishes are, those can be smooth waves and not a tidal wave, or smooth ripples and not a tidal wave. So thank you so much for coming. We appreciate you being here. We'll see you next month. God bless and have a very safe day.